Hello, everyone. Thank you for joining us today for this highly relevant roundtable discussion on the International Criminal Court's Trust Fund for Victims and the engagement of the United States government. We're excited to have over 200 registrations for today's event, and we look forward to an interesting discussion on new developments in the relationship between the United States government and the International Criminal Court's Trust Fund for Victims, and what these may mean for U.S. support in the Ukraine investigation and beyond. On December 30th, 2022, President Biden signed into law the 2023 Consolidated Appropriations Act, which includes a new war crimes accountability provision, amending the longstanding American Service Members Protection Act of 2002. While the American Service Members Protection Act was interpreted to broadly prohibit U.S. support to the international criminal courts, the War Crimes Accountability provision permits certain kinds of engagement with the ICC related to Russia's invasion of Ukraine. This constitutes a significant evolution in the relationship between the United States and the court. This provision also opens a path for increased engagement with the ICC's Trust Fund for Victims, a fund established to provide assistance to victims of crimes under the jurisdiction of the International Criminal Court and to administer the court's reparations awards. This roundtable will present the findings of a joint project between the Public International Law and Policy Group and Debevoise and Plimpton, exploring the historic relationship between the United States and the ICC and the domestic legal regime, which has historically constrained engagement with the court and, by extension, with the trust fund. I'm Milena Stereo, Managing Director at the Public International Law and Policy Group and the Charles R. Emmerich Jr. Calfee, Halter, and Griswold Professor of Law at Cleveland State University's College of Law. I will moderate today's roundtable. The roundtable will be 60 minutes long. This event is co-sponsored by our partner, Debevoise and Plimpton, a premier global law firm and a long-standing pro bono partner of PILPG. We have worked with Debevoise across a wide range of topics, and for this project, we're particularly grateful to Florian Laveau, Ashika Singh, and Isabel Glimcher for their diligent work on the question of whether the United States can contribute to the ICC Trust Fund for Victims in accordance with domestic law. We're grateful for their enduring support. Today's event will be recorded and subsequently posted on our website. We ask that you please submit all questions using the Q&A function on Zoom, and we will do our best to answer your questions throughout the event. Today, we have assembled a highly esteemed panel that includes Ambassador Beth Van Schaack, Franziska Eckelmans, Florian Laveau, Ashika Singh, Dr. Yvonne Dutton, and Dr. Paul Williams. We're honored to welcome Ambassador Beth Van Schaack. Dr. Van Schaack was sworn in as the U.S. State Department's 6th Ambassador at Large for Global Criminal Justice on March 17, 2022. In this role, she advises the Secretary of State and other department leadership on issues related to the prevention of and response to atrocity crimes. Prior to returning to public service in 2022, Ambassador Van Schaack was the Leah Kaplan Visiting Professor in Human Rights at Stanford Law School. Earlier in her career, she was a practicing lawyer at Morrison & Foerster, the Center for Justice and Accountability, and she also worked at the Office of the Prosecutor of the International Criminal Tribunals for Rwanda and Yugoslavia in The Hague. From 2014 to 2022, she served as executive editor for Just Security, an online forum for the analysis of national security, foreign policy, and human rights. I'm also excited to welcome Franziska Eckelmans, who currently serves as the acting executive director of the International Criminal Court's Trust Fund for Victims. With over 16 years of experience in international criminal law, Franziska has dedicated her career to promoting justice and accountability. After starting her legal career in Germany, Franziska worked as a legal advisor for the Extraordinary Chambers in the Courts of Cambodia, where she provided legal advice to Cambodian judges of the trial chamber and worked on high-profile cases related to the Cambodian genocide. She then joined the International Criminal Court in The Hague, serving for over 13 years in various roles, including advising judges, drafting legal documents, and providing legal analysis on complex issues. We also have with us Florian Laveau, counsel and member of the International Dispute Resolution Group at Debevoise Plimpton in New York and Paris. Her practice focuses on public international law, international arbitration, and complex litigation, with a particular emphasis on the Middle East. With over 15 years of experience, She has advised and represented multinational corporations and sovereign states in a variety of jurisdictions and fora on issues of civil and common law, public international law, and treaty and contract interpretation, including before the International Court of Justice. I would also like to introduce Ashika Singh, counsel and member of the International Dispute Resolution Group at Debevoise and Plimpton, whose practice also focuses on public international law, and in particular, representing sovereigns before the International Court of Justice and other international fora. Prior to joining Debevoise, Ashika was an attorney advisor in the Office of the Legal Advisor at the U.S. Department of State, where she has advised the department on various legal issues relating to military operations, counterterrorism, and diplomatic security. She has represented the United States before multilateral bodies and coordinated with the Interagency on International Legal Claims in Guantanamo Military Commission's prosecutions and other federal cases. We're also pleased to welcome Dr. Yvonne Dutton, Senior Legal Advisor at PILPG and a Professor of Law at the Indiana University Robert H. McKinney School of Law. Yvonne has practiced law as a federal prosecutor in the U.S. Attorney's Office for the Southern District of New York, and also practiced as a civil litigator in law firms in New York and California. Professor Dutton has recently been involved with providing technical assistance with the development of framework laws on transitional justice and the harmonization of Ukrainian domestic laws with international humanitarian law. And finally, we're joined by PILPG President and Founder, Dr. Paul Williams. Paul holds the Rebecca I. Grazier Professorship in Law and International Relations at American University, where he also teaches in the School of International Service and also at the Washington College of Law. As a world-renowned peace negotiation lawyer, Paul has assisted over 24 parties in major international peace negotiations and has advised numerous parties on the drafting and implementation of post-conflict constitutions. Full speaker biographies are available on the PILPG website. Welcome, everyone, and thank you for agreeing to participate in today's panel. I'm going to begin this discussion with a broad question to Ambassador Van Schaack. If you can tell us, why is it important, or do you think it's important for the United States to support the Trust Fund for Victims?
Great. Thank you, everyone, for being here, and thank you for including me in this really timely discussion. Thanks also to PILPG and to Debevoise for the very astute research that you've done in this question. It's really helped us to crystallize our own thinking here in the US government. I know that others will talk about some of the legal issues, but for many years, I have been very interested in thinking about whether or not the United States could contribute to the Trust Fund for Victims. We are not a party to the Rome Statute that created the International Criminal Court, but that does not stand as a bar to support for the court itself or for the Trust Fund for Victims. For many years, there was a statutory provision in place that barred any direct funding to the court. The American Service Members Protection Act did allow for the provision of in-kind assistance, and the US government has done that now for many years, but there was no ability to actually fund the court. There was an open question, however, as to whether the Trust Fund for Victims fell within that prohibition, because it's very much an independent institution. And this is where the research by Debevoise and PILPG has been really groundbreaking in terms of looking at some of the corporate law elements that would help bear on whether or not two institutions were functionally separate. And I know we'll get into that a little bit later. Recently, though, the legislation that Milena mentioned has lifted that ban on providing direct funding to the court. And so now we have no legal impediment and theoretically also no policy impediment either. So the real question is, where's the money? But from a policy perspective, which is really at the core of your question, this is an institution that's doing incredibly important work in the field with the most vulnerable communities. These are communities whose situation broadly is being looked at by the court, but they're not necessarily all individuals who are participating actively in court proceedings. And we know that there can sometimes be some tension between situations in which only victims or survivors who are directly testifying, for example, get access to forms of reparation. This is not the case before the ICC, and it's not the case with respect to the Trust Fund for Victims, which, as Francesca will talk about, can begin to operate immediately as soon as a matter has been opened. The United States has long supported many organizations that are working within survivor and conflict impacted communities. We're funding some of the same organizations that the Trust Fund has partnered with. So for all of these reasons, it would make sense for us, I think, for the United States to be in a position to be able to fund the Trust Fund, because it is able to establish trusted relationships with vetted organizations that are doing very good work to an extremely high international standard, and can have a sort of bird's eye view to make sure that resources are being spread fairly and effectively and in a logical way around a particular community in order to touch on the various needs, medical, psychosocial, livelihood assistance, all of that. And so I'm really keen to hear the rest of this conversation about some ideas for how to generate both political interest within Congress, but also to identify funding that might be able to go towards the Trust Fund for Victims, particularly now that we have a green light from Congress to think about this. So I'll stop there.
Thank you. Now, my next question is for Francisca. Francisca, can you give us an overview of the Trust Fund for Victims? What is its mandate? How and where does it operate? And where does its funding come from?
Thank you, Professor, and thank you for inviting me to this roundtable. And in particular, my thanks go to this very thorough study that is really timely. So thank you very much for that as well. The Trust Fund for Victims is a unique institution situated with the International Criminal Court, being an essential part of the Rome Statute's reparative justice system. When the ICC enters a conviction, the TFV steps in and devises a plan for reparations for victims of the convicted crimes, with or without the funds of, if any, of the convicted person. So far, we have been implementing reparations in 3 cases, 2 more to start soon, and the relevant reparations orders of the ICC were directed against the convicted persons at a value of respectively 1 or 10 million US dollar and 2.77 million euro. In ICC situation countries, that is where the ICC exercises jurisdiction, the TFV can provide reparations to victims without an accountability finding. The focus lies on whether the crimes have been committed. We are active as of 1 April 2023 in 7 ICC situation countries with country programs. In Uganda, we have addressed about 68,000 direct beneficiaries since 2008. In the DRC, more than 50,000 direct beneficiaries as well since 2008. Many of them victims of sexual and gender-based violence. In addition, we have trained capacities, including psychologists, got involved in peace education, and addressed victims through many other training sessions and radio missions. In the Central African Republic, where the ICC acquitted an individual, we are active since 2008 and since 2020 and provided holistic reparations to more than 8,000 direct beneficiaries, about 80% of which victims of sexual and gender-based violence. In Côte d'Ivoire, we are nearly the only organization active in the justice sector and are in the process of providing reparations to communities and victims of 13 incidents of crimes against humanity and war crimes. The programs in Georgia, Kenya, and Mali are at the startup phases. The TFV brings reparations to victims of crimes against humanity, war crimes, genocide, and the crime of aggression. We focus on recognizing victims for the harm suffered and empowering them to overcome their personal harm, ideally through the involvement of victims, communities, and civil society in the reparations process, and through providing physical, psychological, and socioeconomic rehabilitation to them and their families. Part of these transformative reparations are also symbolic measures for the victims and their community, essential to a process of healing. This holistic approach to the healing of victims is extraordinary because its focus is on the future, on the building of societies that have effectively addressed the past harm, thereby ensuring in the long run peace and stability. Our goal is to enable victims to take part in this and to allow them to raise their children while being able to acknowledge and live with the harm they suffered. This mitigates the otherwise negative transgenerational effects of the heinous crimes. In addition, enabling victims to again take up their roles in their families and societies has a strong developmental effect In our work, we work as a matter of course towards quite a number of the United Nations SDGs. Looking at the past conflicts, rebuilding the country, providing for basic needs is often where the funds of states and donors go to. It is therefore essential not to raise expectations of victims of such conflicts that they would receive full compensation or full restitution. However, to move forward, transformative reparations, which is much less costly and has sustainable effects, is absolutely essential. I strongly believe that this transformative work of the TFV makes it worth of donations going far beyond our yearly income of lately about euro 4 million. And the more than 40 million received over time, and much of which we already invested in the programs I just mentioned. It's important to underline that our 24 staff and core operations are funded by the Rome Statute's Assembly of States Parties. The budget for 2023 is euro 3.8 million. In other words, every penny provided to the trust fund as a fund goes to program-related costs, in particular to our 29 current partners worldwide. In addition, the registry is an important source of support for the TFV in every respect of its operations. The funds of the trust fund are overseen separately and independently from the funds of the ICC. A pro bono board of directors consisting of 5 members elected by the ASP and representing the 5 UN regions has oversight and selects the executive director of the TFV, who has the responsibility for the day-to-day functions. The board allocates the funds to complementing ICC reparation awards and to country programs. It also approves decisions such as the start of a country program or draft implementation plans. This is not a decision by the ICC or the judges, but by the independently acting board. Our main source of income are states' voluntary contributions, but we can also receive contributions from private actors. Convicted persons have to date contributed a total of euro 330,000 received in fines in an administration of justice case. Therefore, part of our mandate is also to fundraise, and we are in the process of investing and reinforcing this area. We will very soon be looking for a fundraiser, the only post we currently have. So those interested, please keep an eye on our website. Finally, part of our mandate is also to share our expertise in reparation implementation. This includes providing advice to the ICC chambers, but also to states, the UN and the EU. We are in the process of deepening our expertise, that is becoming a hub of expertise, ideally forming an alliance around this unique TFV, an alliance of states, experts, university, and other pro bono supporters. All of you, when you support the TFV's reparation programs, you support justice, peace, stability, but also contribute to the SDGs. We look forward to working more intensely with you. Thank you.
Thank you so much, Franziska. Now, my next question is for Florian. Florian, as part of Debevoise's research on this project, you looked at the historic relationship between the United States and the Trust Fund, as well as the ICC in general. How has the relationship between the United States and the ICC shifted over time?
Thank you, Milena. It is really an honor to participate in today's event with you all and to contribute on this important topic. To respond to your question, I will start by saying that the relationship between the United States and the ICC has not been straightforward. In fact, it has shifted significantly since the adoption of the Rome Statute in 1998. It actually started in 2000 when President Clinton signed the Rome Statute affirming the US's strong support for international accountability. But then 2 years later, in 2002, President George W. Bush changed course by declaring that the US did not intend to become a party to the treaty, and that it understood that it had no obligations at all under the treaty despite its earlier signature. And the way that Secretary of State Colin Powell at the time sought to justify this about face was by emphasizing the need to insulate US persons and allies from the jurisdiction of the ICC. Now, those are actually the concerns that led to the passage of key pieces of legislation that Milena and Beth, you mentioned at the outset, and that we'll go into further detail in a moment, and which really characterize a long period of hostility between the US and the court. Now, you will remember moving forward to 2009 that the situation again changed when the Obama administration showed an openness to the ICC and emphasized that it was an important tool to hold accountable senior leaders responsible for atrocity crimes. And I'll just give a couple of examples. In 2009, after the ICC issued an arrest warrant for then Sudanese President Omar al-Bashir, the Obama administration launched a re-examination of whether the US should actually formally join the ICC. The US also played a role in the transfer of to the ICC of two African leaders, that is Bosco Ntaganda, a militia leader from the Democratic Republic of Congo, who you will recall turned himself in to the US Embassy in Rwanda. The second one is Dominique Ongwen, a special commander of the Lord's Resistance Army, who was captured by US Special Forces in the Central African Republic. We mentioned that just a second ago. The United States also voted in favor of the UN Security Council referring Libya to the ICC in 2011. And most recently, we have really seen a renewed interest in the court as a mechanism to hold Russia accountable for its actions in Ukraine, especially in Congress. This is, of course, not limited to the US. Countries around the world have called for accountability through the ICC, and the ICC has taken action, including by issuing just last Friday an arrest warrant for Russian President Vladimir Putin. But then at the same time, the US Department of Defense has reportedly opposed sharing of American intelligence relevant to ICC investigation related to Ukraine. So it seems that there's still some tension, maybe some disagreement, even at the highest level of the government, as to the appropriate relationship between the US and the court. Thank you, Milena.
Thank you, Florian. Now let me go to Ashika next. Ashika, what are the key pieces of legislation which shape the US relationship with the International Criminal Court?
Thanks so much, Milena, and it's wonderful to be here with such esteemed colleagues to address these important issues. So there are three key pieces of federal legislation that shape the U.S. relationship with the ICC. First, the Foreign Relations Authorization Act for fiscal years 2000 and 2001, which I'll refer to as the FRAA. Second, the American Service Members Protection Act, which the ambassador already mentioned, also known as ASPA, passed in 2002. And third, the Consolidated Appropriations Act of 2023, which has also been mentioned, which we can call the 2023 CAA. So first, the FRAA includes a provision that prohibits the U.S. government from obligating appropriated funds, and I quote, for use by or for support of the International Criminal Court. Then you had the ASPA come along, which elaborated on this prohibition. It was signed in August 2002. And it was animated really by the fundamental purpose of protecting U.S. persons and allies from ICC jurisdiction, which was the main animating concern that led the Bush administration to withdraw the U.S. signature from the Rome Statute. So to that end, it placed a number of restrictions on U.S. involvement with the court. It prohibited U.S. courts, agencies, or other government entities from 1, cooperating with an ICC request, 2, extraditing a person to the ICC or supporting their transfer, and 3, from engaging in investigative activities relating to an inquiry, an investigation, prosecution, or other proceeding at the ICC. And then also, perhaps most relevantly for our purposes, the ASPA broadly prohibited, quote, support to the ICC, which it defined as providing assistance of any kind, including financial support, transfer of property or other material support, services, intelligence sharing, law enforcement cooperation, even training or the detail of personnel, or the arrest and detention of individuals. One additional point I'll note here that will become important later in the discussion is that both the FRAA and the ASPA define the ICC as, quote, the court established by the Rome Statute, end quote. So taking these provisions together, it may seem as though the ASPA and the FRA prohibit any form of U.S. engagement, at least with the court itself. So what are we even talking about here? The ASPA actually contains 2 waiver provisions that would enable the president to broadly waive its restrictions in certain circumstances, but they've never been used. So I'll skip over discussing them here. More importantly, there was an amendment that was introduced by then Senator Christopher Dodd when the ASPA was passed in 2002, and that established an important exception to the ASPA's restrictions on assistance to the ICC. So under the so-called Dodd Amendment, the ASPA does not prohibit the U.S. government from rendering assistance to international efforts that are aimed at bringing to justice foreign nationals who are accused of genocide, war crimes, or crimes against humanity. And then finally, third, we have the 2023 CAA, which includes that new war crimes accountability provision, which Florian will discuss in greater detail later. So we analyzed the relationship between these laws and also looked at the binding interpretation of the ASPA and the FRAA that was issued in 2010 by the Justice Department's Office of Legal Counsel, or OLC, to identify whether and how the U.S. could contribute to the trust fund by any means.
Thank you, Ashika. And then as a follow-up question, are there any forms of engagement with the International Criminal Court which are permissible in light of all these various legal provisions which you just outlined for us?
So that was essentially the question that the Obama administration asked itself in 2009, which led to the issuance of that 2010 OLC memo that I just mentioned. And what the OLC determined was regarding ASPA and the Dodd Amendment, they confirmed that the Dodd Amendment creates a carve-out that does permit the U.S. to render assistance to the ICC in the situations listed in the amendment. So in relation to efforts to bring to justice foreign nationals who are accused of genocide, war crimes, or crimes against humanity. And then with respect to the FRAA, the OLC interpreted the prohibition on funds, quote, for use by the ICC as prohibiting contributions of funds for the ICC to use in a self-directed way. And then the OLC interpreted the separate provision against funds for, quote, support of the ICC to prohibit contributing funds that would be used to support the ICC as an institution, as opposed to in aid of particular cases. So then taking all of these principles together and those 2 points of interpretation, the OLC adopted 3 overarching principles to guide permissible U.S. engagement with the court. First, it determined that the U.S. could not provide the ICC with any funds that have been authorized to be appropriated, regardless of whether the funding is for institutional support or for case-specific activities. Second, OLC determined that the U.S. could engage in diplomatic activities related to the ICC, for example, voting in favor of a UN Security Council resolution to refer a matter to the ICC, which, as Florian mentioned, the U.S. did end up doing with respect to Libya. And then third, in light of the Dodd Amendment, the OLC determined that the U.S. could provide informational assistance, training, and even detail government employees to the ICC when this assistance is limited to the particular cases as set out in that amendment. So as long as they involve foreign nationals who were accused of genocide, war crimes, and crimes against humanity.
Thank you. And another follow-up then to Florian. Florian, Ashika mentioned the 2023 Consolidated Appropriations Act, which includes a war crimes accountability provision. What does this new provision say, and how does this change the legislative regime that was in place before the end of last year?
Thank you, Milena. So you're quite right. I mean, the war crimes accountability provision, as it is called, which was included in 2023 CAA, quite significantly changed the legislative regime. As you mentioned at the beginning, the new provision really amended the Dodd Amendment, which Ashika just mentioned a second ago, by explicitly allowing the U.S. to, and I quote, render assistance to the International Criminal Court to assist with investigations and prosecutions of foreign nationals related to the situation in Ukraine, including to support victims and witnesses, end of quote. Importantly, the provision applies notwithstanding the prohibitions under FRA on funding that Ashika mentioned earlier. So the plain text of the provision really creates a carve-out for contributions related to the situation in Ukraine, including to support victims. So it therefore allows the United States to contribute to the ICC's victims assistance programs related to Ukraine. And in that sense, it really is a major development that indicates a heightened openness to the court, at least in the context of Ukraine.
Thank you. Ambassador Van Schok, would you agree? Do you think that the passage of this new provision indicates a change, a shift in the relationship between the United States and the International Criminal Court?
100%. I mean, the last word from Congress was the original statutes that Florian and Ashika have mentioned. So the first being the FRA, as we called it, which was this per se ban on any sort of funding to the court. And then the second being the American Service Members Protection Act, which had a whole list of prohibitions. Can't do this, can't do that, can't do that. Now, that did include the Dodd Amendment, which basically allowed for some in-kind assistance to international efforts, which was interpreted by the Office of Legal Counsel to include the International Criminal Court for the prosecution of foreign nationals accused of the three core international crimes: genocide, crimes against humanity, or war crimes. And so to the extent that the United States was able to provide assistance, it had to fall within that Dodd Amendment, which in most cases it did, with respect to the various matters that were under consideration by the court. Now, though, we have a strong, and Congress did over the years, as was mentioned, declaw the American Service Members Protection Act in a couple of ways, but the core of it remained the same. Now we have new affirmative language that is very supportive of U.S. participation and cooperation with the court, even as a non-party state. And we have this green light to provide direct funding to an institution of which we're not technically a member. So that, I think, really does signal a new era. This was very much inspired by Ukraine, but I think it's also been inspired by just seeing the court operating, frankly, having the prosecutor indicate that he's deprioritizing the investigation against U.S. personnel in Afghanistan. I think that helped considerably. And also the fact that the court is often literally the only option for justice for many communities that desperately need it, because the state itself is foreclosed, because it is perpetrating these abuses against its own civilians. There isn't an ad hoc tribunal available. There may be the chance to do one-off episodic cases in national courts under principles of universal jurisdiction, but it may be that the ICC is sort of really the only game in town. And I think Congress now recognizes that it plays an important role within a larger ecosystem of international justice. And so Congress wants to be in a more friendly stance when it comes to the court. So now we have kind of a whole new legal framework in which we're operating, and we're still sort of exploring what that entails, what that allows, what the interagency will accept, because there's still the policy question of whether or not at least at the executive branch level, is willing to utilize to the full extent all of the new authorities that Congress has given.
Thank you. And maybe the relevant question for the next roundtable is then if funding is actually made available. We know that the U.S. can now contribute financially, but it's quite another question then to have specific funds available. But we'll leave that question to the next roundtable. My next question is for Paul. Paul, what sorts of opportunities may exist now politically for the United States in light of this new provision?
Well, thanks, Milena. I think there is an incredible political opportunity now for the United States to right-size its relationship with the International Criminal Court, and to also double down on its emphasis of the rights of victims and the need for compensation or reparation for victims. Florian and Beth have done a very good job of articulating the U.S. interest in justice and our rather complicated relationship with the ICC. If we continue to pull back the lens, we realize that Congress, the American people, traditionally the executive branch, are deeply committed to the notion and the norms of justice and the framework for accountability. When we talk about justice now, conversation immediately goes to our rather complicated relationship with the ICC. But stepping back, the United States played a key role in creating the Yugoslav Tribunal, funding the Yugoslav Tribunal, seconding personnel. Same with Rwanda. You know, the chief prosecutor of Sierra Leone who indicted the head of state, Charles Taylor, first ever, was an American, formerly with the Department of Defense. And so we have a tremendous track record of commitment to justice that was dislodged a little bit. But now this gives us the political opportunity to get back on track, realizing that justice is a core element of ending conflict, building durable peace. And you can only do that with adequate and substantial contribution to victims, both reparation as well as cathartic process. So I'm excited.
Great, thank you. Now let me go back to Francisca. Francisca, the trust fund used to prohibit earmarked contributions, but that changed after an amendment to the regulations in 2007. What motivated this change, and how have earmarked contributions been important to the work of the trust fund since then?
Indeed, in 2004-2005, the Rome Statute member states originally did not provide for earmarked contributions in our legal texts. Perhaps they had agreed that their preference were unrestricted contributions to the TFV and probably expected from each other to make really high contributions, because also fundraising is not prominently featuring in our legal text. But the management of funds expected to be there does. So in addition, they may have thought at the time that earmarking was a means of taking too much influence as well. From today's perspective, this appears surprising, as earmarking has become a much more important tool for all states to direct their scarce funds, in particular in the areas of development and peace and justice. But they cannot provide their funds on their own initiative. The board of directors or the executive director may invite states to earmark. In our practice, we are very open to adapt to states' earmarking requirements. States are, for example, earmarking to court-ordered reparations in general, to specific cases, to programs that focus on sexual and gender-based violence, or to country programs, assistance programs. We are changing the terms, you mentioned that. Canada, for example, is an important donor who earmarked $4 million Canadian to programs run in Mali, in particular to the country program in Mali and to specific projects of the court-ordered reparations case of Almadi Al-Faki and to related program costs. In our work of today, earmarking is very important as it provides us with the possibility to meet the specific requirements of states and their policies, in particular in the area of development assistance. When aiming at opening additional programs in ICC situation countries, earmarking is particularly important because we need to focus with our unrestricted funding to the extent possible on court-ordered reparations. This means that if we want to open a program in Ukraine, in Libya, or Darfur, pending a conviction or reparation order by the ICC, we would only act on the basis of earmarked donations to support such programs, including all related costs for running this program. For example, the Canadian grant supports also human resources and gender and conflict sensitivity consultants, important to run this specific additional program. It's not for the donor, but for the board of directors to decide to start such a country program upon a preliminary assessment of the situation, the needs of the victims and the direction the program needs to take. It's also for the TFV to then solicit such a donation in a process of consultation with the relevant state, of course, who showed interest in providing such a donation. Accordingly, the manner in which the 2007 amendments to the TFV's legal text were drafted ensures the independence of the TFV and its actions, but also, and very importantly, enables it to get the much needed earmark contributions and to extend by these contributions its sphere of influence, its programs to new situation countries. Our interest to start activities, including exchange of expertise, but also a program in relation to the Ukraine situation, is extremely high. not least because we can contribute with such activities and programs to establishing a reparation system in Ukraine, which is led perhaps by the state itself and takes into account transformative reparations. It will be our message and goal to focus on the victims, the children, now in particular, and women, and the harm they suffered, and enable them to address and live with this harm. Only then can we achieve peace and stability in the long run. Thank you.
Thank you. Now, let me return to Ambassador Van Schaack. Do you think that the United States should consider making a contribution to Ukrainian victims through the trust fund? And if so, what are some factors to consider in weighing whether or not to make such a contribution? Do you think that the political will exist to make such a contribution presently?
Yeah, I imagine it does. I mean, there's also a new initiative to establish some kind of reparations fund or claims registry for the whole conflict within Ukraine. That could be open to any number of individuals or entities who have claims against Russia in connection with Russian aggression. What's interesting about the Trust Fund for Victims is it tends to focus on individuals and those who are most vulnerable. And so you can imagine these two new institutions working in parallel with each other, with the Trust Fund for Victims focusing much more at the grassroots level. So again, it comes down to finding available funding. What I've learned being in government, which is something I never understood before because my little office never had programming money until several years ago, money comes in different flavors. And so it gets appropriated by Congress to serve certain purposes. And the appropriation cycle is quite a long one. So if we want to have funds available within the next couple of years, requests need to sort of go in now so that they're built into future budgetary determinations. So the problem is, of course, finding existing pots of money that are relevant enough that they can be used for this particular purpose. Some of my funding, for example, has to be competitively sourced. So I don't have discretion to be able to spend this money where I want to. I have to actually host an application process whereby proposals come in, we have a panel of multidisciplinary experts who will evaluate those projects, make certain recommendations. We will then ultimately decide how those funding should be served. So it's been difficult in the past sometimes to fund institutions like the Trust Fund for Victims or the IIIM, which is the investigative mechanism that's focused on Syria, because they're not really in a position to apply competitively for funding. They're used to receiving money from states more directly. We're looking for ways around some of those restrictions to open up our competitive processes to these sorts of multilateral institutions so that they could apply and be considered along with other more traditional civil society organizations. So there's lots of ways that we can imagine coming at this question, but my recommendation for advocates out there interested in seeing the United States support this, start working with appropriators now within Congress in order to lay the groundwork for a sort of reliable stream of funding that could be used, or maybe it's a 3-year grant or a 5-year grant that could be given to the Trust Fund for Victims. Get it into the budget now so that when the appropriations bill is finalized at the end of this year, it's included in there, and then we can move forward in the next calendar year.
Thank you. My next question is for Yvonne. Yvonne, how do you assess the legal possibility of the U.S. making other contributions to the trust fund in the future to assist victims in conflicts other than Ukraine?
Thank you, Milena. Well, as to legal possibility, so we learned that the new war crimes accountability provision modifies the past laws that many had concluded constrained the ability of the United States to contribute to the Trust Fund for Victims or to the ICC more generally. And Ashika told us about those past laws that prohibited certain support to the ICC. And Ashika noted that those laws define the court very specifically because those prior laws talk about support to the court. Now, the new war crimes accountability provision is very specific to Ukraine. And Florian spoke to this. It references not prohibiting rendering assistance to the International Criminal Court to assist with investigations and prosecutions of foreign nationals related to the situation in Ukraine, including to support victims and witnesses. And so this portion, of course, could then allow, this new law would allow the United States to support victims and witnesses through the trust fund for victims if they wish. Now, as to other situations, I will, rather than going into a great amount of detail, this is something that Professor Stereo and I, our moderator, argued about in a recent Just Security blog post, and we talked about the prior laws that have been spoken about already. And we do believe, and we make the argument, that the United States could still provide funding to the Trust Fund for Victims because the Trust Fund for Victims is a separate entity from the International Criminal Court, and those laws speak very specifically to not supporting the International Criminal Court. And as Ambassador Van Schaack mentioned, she mentioned this possible argument actually in her opening remarks. Now, we fleshed this out in some detail in this blog post with Just Security, and I hope that interested listeners will read that post. But we point out a few things, and some of these Francisca pointed to as well in her remarks, how the ICC, the Assembly of States Party, and the Trust Fund for Victims are actually separate entities, right? So we heard the Trust Fund for Victims has its own separate board, separate bank accounts, and very importantly, we think, is the fact that the Trust Fund for Victims does not receive any programmatic support from the International Criminal Court or from the Assembly of States Parties. It gets its, it takes voluntary contributions, for example. Now, of course, whether the United States will contribute to other, victims in other situations beyond Ukraine, I would think it would be more likely to do so, one, if it agrees with the interpretation that we have of even the prior laws, that the separateness of the Trust Fund for Victims means that the United States could contribute, but also I think it's more likely that the United States would contribute in situations that probably were not as politically controversial. So I'll leave it there.
Thank you. Now, let me take the opportunity now to go to some of the questions that we have received from our audience members. So there's a question specifically directed to Ambassador Van Schaack about basically the likelihood of expanding the war crimes provision, the amendment, to encompass additional situations beyond Ukraine. For example, you and I just recently visited Bangladesh and worked in the, visited the Rohingya refugee camp. So Myanmar might be one situation. How likely is it to see, the possibility of this amendment broadening in the future?
Yeah, thank you for that question. I would like to see that. I think this is a little bit of a trial run, getting Congress comfortable with the idea of a closer relationship between the US and the ICC in a situation that's completely uncontroversial. There's no concerns raised by it. The messaging around accountability has been very strong from both political branches of the United States. And so there is a lot of support. But of course, I think there's also a lot of support for other areas. The US has been a strong supporter of the Darfur prosecutions. Those are just now getting off the ground with the first trial underway of a high-level regime figure. Likewise, you mentioned the Rohingya case. And so I think it remains to be seen whether Congress is interested in expanding that. But I know that advocates who care deeply about those situation countries will be working with their allies on the Hill in order to encourage language to be used there that would broaden that. Sorry, I don't know why my camera has suddenly become very blurry, but here I am. But so yes, I do think this is a very much a possibility. I'd love to see that.
Well, I can assure you that we can hear you really well. So the image is a little blurry, but the audio is very clear. Thank you for that answer.
Yeah.
Another question that has come in from the audience asked whether the announcement on Friday regarding arrest warrants issued against Putin might also encourage the US to cooperate more with the International Criminal Court. So this question really looks at this a little bit more broadly, not just the trust fund, but also the ICC. So if you don't mind, Ambassador, I'll direct it to you, but then I'll open it up to all our other panelists as well.
Yeah, I imagine. I mean, there's been very strong calls for, Putin has been described as a war criminal by senior officials. There's been a war crimes and a crimes against humanity determination by the Secretary of State with respect to Russia's troops We have the Conflict Observatory that is an independent institution, but that is being funded by the United States State Department, that is focused very much on different types of war crimes, such as attacks on cultural property, et cetera. So there's very strong support for accountability here. And now we have something tangible from the court and a very clear division of labor between what the Prosecutor General is doing in his own docket in the national courts of Ukraine and what the ICC can take on. And I know those two prosecutors are in regular touch with each other, kind of coordinating who's going to take which cases. And so the division of labor is one in which most of the direct perpetrators who may actually be, and some of them in Ukrainian custody, otherwise they can at times be proceeded against in absentia, those cases would be done in Ukrainian courts. And now we have these two senior figures being subject to arrest warrants at the ICC on a very narrow charge, one of the deportation of children. And the Conflict Observatory has done a very extensive study of this phenomenon and has been able to confirm with high levels of certainty 6,000 children that were taken from occupied areas within Ukraine, other parts of Ukraine, or had been sent to Russia potentially for their safety, but now are not being allowed to return. And they have families or guardians who want those children back, who want to be in touch with them, and that's being disallowed now. And many of these children are being subjected to sort of sham adoptions with Russian families. And so this is an issue that I think is very, it's a very sympathetic issue. It's a very clear crime base. It's a grave breach of the Geneva Conventions. And so, it remains to be seen, but I would hope that this would encourage greater cooperation with the court, because it's such an obvious case for the court to be taking on. Extreme, widespread, and systematic violations, and zero possibility of any accountability at all in the relevant domestic situation that is Russia with respect to the nationality of the primary perpetrators.
And let me actually also ask our other panelists, would anybody else like to weigh in on this one? Because obviously the big news in the world of international criminal justice, most recently has been the arrest warrants issued by the ICC, particularly the one directed against Putin. So any other thoughts on this, whether this might now influence the developing relationship between the US and the ICC? Paul?
Yeah. Thanks, Milena. Now, just to amplify what Beth had said, I think this reminds everybody, and literally everybody in the global community, why the International Criminal Court is so important. It's clearly a part of America's and the global South and the European approach to a durable peace in Ukraine to hold the Russian leadership accountable for these widespread and systematic atrocity crimes. And we see the International Criminal Court being brave, being assertive, coming right out of the gates and indicting the head of a state, of a permanent 5 nuclear powered former superpower. It's not shy, it's doing what we want an institution like this to be doing, coupled with our policy. Now, people immediately say, whoa, wobbly, US and ICC, but Secretary Blinken came out, declared crimes against humanity were occurring. President Biden has declared war crimes, has pointed to President Putin, said, yep, and it's him that's responsible. It's woven into the US approach for durable peace. Justice is woven into a US approach to durable peace in Ukraine. And the ICC is right there with us. I think that's an important sea change in our relationship with the ICC. So brilliant move, completely legally justified to indict Putin for stealing Ukrainian children.
And Ashika, apologies if I didn't see you, but did you want to weigh in as well?
No problem. I was just going to observe that one of the other attendees also raised a question that I think is sort of the flip side of this, which is, does the arrest warrant for the Commissioner of Children's Rights indicate that the ICC is looking to prosecute relatively mid-level individuals, and could that impact US-ICC relations? I presume they mean sort of in the opposite direction, raising the specter that the ICC may be willing to go over more junior individuals. Does that mean they may be willing to go after, more junior Americans as well, if that potential, possibility raises itself. I can't really speak in terms of sort of internal Russian government structure as to how senior or mid-level this particular individual is. I mean, she is a presidential appointee. She did seem to directly oversee this policy of deportations herself. So I'm not sure if I entirely agree that this is a relatively mid-level individual, but I think the question still stands about the internal, domestic U.S. fears about the ICC coming after Americans. I don't think that that's something that we've entirely stamped out of the political discourse here, unfortunately. And it also speaks to another question that was raised about the potential for the U.S. to potentially ratify the Rome Statute one day. I mean, it would have to go through, this is really the sort of treaty that should go through the Senate for advice and consent, which means that you need 2/3 of the Senate on board. And I don't know that 2/3 of the senators have entirely let go of this fear that the ICC could come after Americans in some sort of unjustified way. But I hope that one day we can get there.
Thank you. And I think obviously that question of the U.S. ratification of the Rome Statute is an important one, but I think that's a discussion for a whole other series of panels. I don't think we can adequately address that in the remaining few minutes. Paul, let me ask you one more question, kind of a follow-up to all of this. What are some United States strategic interest in contributing financially to the trust fund, especially in light of the current situation where the court has now issued an arrest warrant against Putin, which really might be in the U.S. geopolitical strategic interest as well?
Yeah, Milena, not to put too fine a point on it, but American leadership is key to the global order, to the rule of law-based order. As much as we'd like to pretend otherwise, those of us that teach in our classrooms, we've seen that the Ukrainian conflict has reaffirmed the need for American military leadership in NATO, the need for American economic leadership in sanctions. And quite frankly, it's also needed in the arena of justice. Justice is weaker than it could be because of the, until recently, lack of American leadership. This signals a return, starting out baby steps. It's a beachhead, providing assistance, appropriating money to the victims fund is a way of aligning ourselves with other like-minded states that are committed to justice, committed to the rule of law. And it signals, it's in our strategic interest to signal that we're back and we're moving fully into the game of justice, because justice, economic sanctions, supporting Ukraine's right of self-defense is how we end this war and get to a durable peace in Ukraine.
Thank you. Unfortunately, that's all that we have time for today. Thank you for joining us today for this roundtable, and thank you for submitting your questions. The webinar has been recorded, and the recording will be available on the PLPG website and also shared with all the attendees via email. Thank you very much to our panelists for taking the time today to talk about the relationship between the United States government and the International Criminal Courts Trust Fund for Victims. I encourage everyone to follow this thought leadership initiative and to join us for our next roundtable, which will be on prosecuting Putin next steps and which will take place this coming Friday, March 24th at 12 p.m. Eastern Standard Time. Thank you to all of our panelists and to all of our attendees.
Thank you, everyone.
Thank you so much.
Thank you.
Thank you.
Thank you.